The text of the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The Fourth Amendment seems to be the most detailed and specific of any of the provisions of the Bill of Rights, but as we'll see, there's a lot of disagreement about the Fourth Amendment's scope, purpose, and meaning. And these points of disagreement will only become more acute with more and more technological change. The Fourth Amendment's origins can be found in Americans' reactions to the British abuses before the American Revolution. The British Crown had always issued general warrants, or writs of assistance, which allow British and Crown officials, mostly customs officials, to search a home, ship, or office. Moreover, these writs of assistance were often open-ended, meaning they were good for however long the officials deemed necessary. Writs of assistance became more frequent and more controversial on the eve of the Revolutionary War, as the colonists were facing and resisting new customs and tax levies from the Crown. These were the immediate experiences of the founders who wrote the Fourth Amendment, and even before the Fourth was written, most states had similar amendments in their state constitutions. Moving on from the historical origins, we need to identify the aspects of the Fourth Amendment that are subject to controversy and rival interpretation that we'll be studying. What exactly does probable cause mean? We'll use a court-created definition that I'll talk about in a few seconds, but know that there are differing understandings of probable cause. What does unreasonable mean? There is no glossary for the Fourth Amendment, so we have to come up with our own reasonableness standards. Also, are all searches without a warrant unreasonable? Should there be exceptions to the warrant requirement? We'll see that the court's answer to this last question is yes, and they've created a whole host of exceptions to the warrant requirement. Even considering the differing understandings of the text itself, there are some nuts and bolts basics to the Fourth Amendment that we have to know. One is that as a general rule, police must obtain search warrants for seizures and arrests from a neutral and detached magistrate, a judge. To obtain a search or arrest warrant, police must show or demonstrate probable cause. Probable cause has been defined as, quote, whether at that moment of arrest, the facts and circumstances within the officer's knowledge and of which they have reasonably trustworthy information are sufficient to warrant a prudent man in believing that the suspect had committed or was committing the offense. This test is objective because a judge, the reasonable person, would agree that enough evidence exists to support a police officer's determination. And the test is neutral because it is the judiciary, not the police, making the ultimate decision. Also, the text of the Fourth Amendment makes it clear that warrants need to be specific about what they're looking for and that they detail the location of the evidence in question. That specification helps guarantee that there is protection for the person and their property beyond the location specified in the warrant. Even though the general rule is that warrants need to come before arrests and seizures, that standard may not always be possible to uphold. As a result, the court has developed some exceptions to the warrant requirement. One exception is the plain view exception. Items in plain view to police, though not originally mentioned in the warrant, are subject to search and seizure. Another is a search incident to arrest. If you're arrested, a seizure itself, you can be searched for your safety and the safety of the officer. Exigent circumstances is also another exception. Here, for any number of reasons, it may not be practical for police to obtain a warrant to search or seize. It is thus after the fact, with our definition of probable cause, that a judge will determine if the search or seizure violated the Fourth Amendment. Of course, your consent to be searched is an exception to the warrant requirement. Consent searches are limited, though. For example, your wife or husband can give officials consent to search your home if you're not present. If both of you are present, though, and one consents and the other does not, there can be no search. Related to the plain view exception, there is also the open fields doctrine. That, with some limitations that we'll see, allows searches of property from airplanes and helicopters. There is also, under circumstances which are actually very common, a less stringent requirement than probable cause for police to carry out short investigative stops of individuals if they have, quote, reasonable suspicion. Automobiles also pose a challenge to Fourth Amendment jurisprudence. Should we treat an automobile differently than a house, for example? Houses don't move, but cars do. Necessary evidence might literally drive off if the police had to get a warrant every time they wanted to search a vehicle. Some of the exceptions we've talked about, like plain view, consent, and the lower reasonable doctrine applied to vehicles, but they still pose challenges when interpreting the amendment. So as you begin these Fourth Amendment cases, consider the following questions. Should the Fourth Amendment be taken literally? Should police get a warrant anytime there is a search or seizure? Remember, if you're arrested, you're seized. Do the exceptions to the Fourth Amendment that the court has developed make sense? Are they fair? We'll continue to talk about the Fourth Amendment in the next section, but enjoy these cases. They're fascinating.